Good morning. Welcome to today's meeting of the Select Committee on the Future Relationship with the European Union. Can I begin by asking our witnesses today to introduce yourselves, starting with you, Barbara.
Good morning. My name is Barbara Drozdowicz. I'm Chief Executive Officer of East European Resource Centre.
And then Kuba.
Good morning, my name is Kuba Jablonowski. I'm a research associate with the 3 million.
And finally, Luke.
Hello, my name's Luke Piper and I'm Head of Policy at the 3 million.
Well, you are all very welcome before the committee today. We are extremely grateful to you for giving up your time to join us. As you know, this is an issue, the position of EU citizens here in the UK, that the committee and its predecessors has taken a very close interest in since the referendum result. It's a little while since we took evidence from you, and obviously a number of things have happened, and we're very keen to explore those today. Can I begin by asking you this question? Clearly, at the start of this process, there were a lot of concerns about what would happen to EU citizens in the UK. And I know you have, and we'll get on to those, particular issues that you are worried about. But looking overall at the situation, at the number of people who have applied for and been granted either pre-settled or settled status, how does what has happened so far compare with the concerns you held at the start of the process? Barbara, can I perhaps come to you first?
Our observation is that in general, broadly speaking, settled status application process is going well. We have our concerns related to the fact that there have been significant delays related with the COVID pandemics, obviously.
Yeah.
That caused not only impact on Home Office own operations, which then sort of second-handedly impacted on people's decisions being delayed or significantly delayed, but also it has very significant impact on the way how citizens can obtain, for example, documentation from their own consular services. It is a very big, we've always had a bit of concern about that because obviously Brexit does not impact the national legislations and the ease of obtaining documents that are necessary to identify yourself to Home Office. Currently, it is getting, it is very important factor in people possibly not meeting the deadline, even the deadline on the 31st of June next year.
Right. Okay. Well, we will indeed come to that. Is there anything, Kuba or Luke, you'd like to add? Yes, Kuba.
Well, I think the question is, what is the basis for assessing whether the scheme is going well or not? And I think that is an unknown, and we'll probably be able to elaborate on it a little bit more when it comes to the EU settlement scheme statistics. Because it is true that there is a large volume of applications that have been processed under the scheme, but the real question is how many applications are yet to come from those who haven't yet applied, and that's the key question which we don't know answer to. So I think without knowing an answer to that, it's really hard to say how well the scheme is going. And the second set of issues is around, is it going well for whom? For some applicants, definitely it is. Some people can evidence their residence relatively easily, get their ID scanned, and get settled status that they are eligible for. But we have specific groups of applicants that we're concerned about, such as young people, such as elderly people, and so on and so forth, for whom it's not that easy, people with caring responsibilities, irregular working patterns, and so on and so forth. So it could be said that it went well for a lot of people, but we don't know how many people are yet to be processed under the scheme, and we don't know what are the inequalities in terms of outcomes of the EU settlement scheme for diverse groups of applicants.
Okay, well, we will come to that. Luke.
Yes, I'm reminded of the submissions that we did the last oral session, which was on the 3rd of July last year. And your question was how does it compare to what we were expecting at that time? And I think what we were expecting was, yes, large numbers of people would apply, and the trend is that is what has happened. But I'm looking at the concerns that we raised there, and I think they're very much the same now, particular groups, issues of access and things like that, which obviously we'll probably go into more detail today. But in terms of where we are now, and if it's what we expected, I'm sorry to say on some of the points it is, but on the plus side, lots and lots of people have applied.
Indeed. Now, one of the issues that you raised, and indeed on which our predecessor select committee made a recommendation, was that of physical proof of status, as opposed to being sent a code which can be accessed online. Now, would you like to say anything further on that? Has that proved to be a problem? Are you worried that it is going to be a problem once we come to the end of the transition period? Barbara?
Yes, unfortunately, it has continued to be a massive problem. Accessing the online profile is not straightforward for users who are not necessarily fluent in IT, let me put it this way. Another issue is accessing the profile when the application is being made with assistance of someone else, a third party. Because quite often it seems to be people don't have access to the details that are being necessary to log in. We have concerns that might lead to exploitation of users as well. So who need to access their profile, they might require to pay for it to someone and so on. We don't have huge body of evidence around the criminal aspect of it, but there is definitely some aspect of exploitation there. Well, finally, people just don't know how to go about it. So the problem is that they tend to operate only on the document that is being sent in PDF by Home Office confirming that the status have been granted, which is not a decision itself. It's just a confirmation of status being granted as a printout. And if that's lost, there is an issue of then trying to break into your online profile. It has been difficult. It has been difficult for support organizations as well to help people use this the online profile. So our concern is that how online profile is also accessed by third parties like organizations or agencies, in fact. So whether that is being accessed, how that will be accessed by the DWP, for example, in relation to benefits, or in relation to healthcare by NHS. We don't know that. And our clients are very concerned about the future they have if they are unable to explain to anyone that they do hold the status and which status exactly it is.
Can I ask, I mean, the two particular areas where this is applicable are getting a job and renting somewhere, so landlords. Have your members, those you are representing, experienced problems, even though we're still in the transition period, with employers and or landlords saying, well, I'm afraid you've got to prove something to me if I'm going to give you a job or rent you this property?
Well, in our case, we have spoken with our members before this session. Yeah. There hasn't been massive drive towards sort of breaking the unlawful discriminating EU nationals. That seems to have stopped some time ago, thanks to possibly information campaign delivered by Home Office itself, because that was the case in 2017-18, where people were asked to prove that they have right to work by confused employers in particular. There were some cases of landlords as well. Now it largely ceased. The problem is, however, is that, for example, in accessing the benefits and tax credits, that seems to be still an issue. It's completely unclear for us how decisions are being made, especially by DWP, in terms of using settled status as a proof of eligibility. Our concerns also are that immigration status is being confused with eligibility for accessing state support, such as social housing allocations. For example, EU nationals sometimes the term used against them is no recourse to public funds, which is immigration rather term than eligibility term. And that allows officials to essentially ignore any immigration status whatsoever. Part of the problem of it is that it exists as online status, so people just cannot show the card and say, well, see here, this is my name, this is my status and my photograph. If that would be the case, especially for people who are vulnerable or seen by system as vulnerable, it would increase very much support accessing the state, the support that people need. It is not now possible, and it doesn't seem to be nowhere near as easy as it is supposed to be for people who are vulnerable.
Okay, Kuba, I can see you want to come in.
Thank you. I just wanted to add to that we, as the 3 million, we conducted a survey with Professor Tanya Bueltman from Northumbria University at the start of the year. And in that survey, we found that over 10% of participants, and it was a survey of more than 3,000 EU citizens, more than 10% of them have already been asked to provide proof of settled status, which they shouldn't have been. So the issue that Barbara was talking about, I think, is still very much a current one, that people are already being asked for proof of status. But to sort of, I think a lot of problems related to future status will only clarify as we go along. So after the transition period, we'll start seeing more and more people using it, and therefore more problems. But what we are seeing right now, and that's also a finding from that survey, is that for a small minority of people who refuse or are wary of applying for EU settled status and who haven't applied yet, the fact that the status is digital and that it tracks the kind of the behaviors that you mentioned, so renting places and getting jobs, is a barrier to applying. 35% of those who are yet to apply said that they were putting off their decision to apply because of the digital status. People are really concerned about it. And perhaps the most important finding of that survey, again, based on more than 3,000 surveys completed, was that the physical proof came right at the top of concerns of EU citizens. Right. 89% said they would like an option, not a compulsory, but an option of a physical proof.
Okay, that is really helpful. Luke, I think you wanted to come in. Yeah.
Yeah. If I can add, it's not just our voices that have expressed wishes for physical documents. There have been a number of charities and organisations that produce reports of their own, and there's been a consistent calling for physical documents based on similar reasons to the ones that we've already talked about now. But if this pursuit of a non-physical document is to continue, or there's no mechanism by which people can get a physical document, there's really going to have to be a real big drive towards communications, towards the public at large, about how digital status works and what that looks like in the wider public frame. It's important to stress that it's not just a question of people having status under the EU settlement scheme by June, or having applied by June next year. There's a whole new immigration system that's going to be implemented. We've got real concerns about how people are going to be navigating that, and a lot of that is going to be down in the communications. So it's not just about the comms of the system to people who need to apply. It's also going to have to be the comms of the immigration system to the public at large, because without that knowledge, and unless the status quo physical documents continues, it's going to lead to some quite significant problems further down the line.
Okay, that is extremely helpful. Right, I'm now going to pass to Nigel Mills. Nigel. I think we can't hear you, Nigel. I don't know why, because you're... No, your microphone symbol is unmuted, but we can't hear you. Can I move to Anthony Higginbottom at the moment, and then I will come back to you, Nigel, if that is all right. Anthony.
Thank you very much, Chair. Thank you to all the witnesses for coming. Barbara, this is probably a question more for you at the minute, but Luke, Kuba, if you want to come in, just stick your hand up and I'll come to you. The Home Office grant scheme has been running for over a year now, and really I just wanted to get a sense from you of what impact that grant scheme's had so far.
Oh, the scheme has been fundamental in supporting people who have problem accessing the scheme, the application process to access it. And I have to be perfectly honest that I don't think that we would be able as a community sector to support our members and community members in accessing the USS application process without the support provided by the scheme. Our concern is that the scheme is in the process of renewing as we speak, but I am concerned that it will not stretch until the end of the application window, and just that also shows how important it is to have this support system in place. The last 3 months of the application window, which is April to June next year, are going to be potentially unsupported by Home Office or the government funding for us, and it will have massive impact on people who need this advice. One reason is because of the immigration advice is actually quite rare and quite specialist advice. It's tightly regulated, and it is not straightforward or easy to become immigration advisor. Also, on immigration advice, on the quality of it, relies a lot of people's future kind of dependence and independence in living in the UK. So that scheme provided that capacity that we have been able to sort of drum up through our individual projects and give people advisors that they need. Also, the quality has been controlled better, and people can rely more on assistance from grant-funded organizations that they would have to do through private means, which are also very expensive for rarity of immigration advice. Finally, the scheme supported very specific immigration advice related to EU nationals. It doesn't look like anything special comparing with other current immigration systems, but it in fact is quite complicated. It is very hard immigration, part of legislation and regulations affecting EU nationals, especially those who experience things like criminal convictions, some past, who might have derivative rights, and so on and so forth. It's rather quite complicated. I honestly I'm not at all convinced that we would be able to support as many as thousands of users that we have without the scheme, and I do hope that the scheme will be continued until it is necessary for EU nationals to be supported in accessing the scheme and in executing the scheme later on, because using this system later on, the new immigration system will also require some support.
That's really helpful. Thank you, Barbara. I think I'm right in saying your organization has received one of the grants. I wondered are there any Home Office reporting requirements or anything like that allows the Home Office to delve into the impact it's having? So they've got that data, which will help them when it comes to extending and looking at that.
Yes, Home Office, we are bound by quite strict reporting regime. We provide numbers, so as in figures of people supported, case studies of types of support we provide, descriptions of the methods of support. So I think that Home Office does have quite a lot of intelligence from many partnerships that have been accessing this funding in particular, to make assessment how it's working, and I am positive that it's being used the funding is being continued for the last 2 quarters of this financial year. Currently, we are in the competitive process of applying for it, and hopefully it will help us to carry on with the funding later on as it's needed.
Yeah, well, so it sounds like it's been enormously beneficial in making sure that the quality of applications going into the Home Office are resulting in a reasonably high success rate, and of the refusals, they're normally for, I think it was 99% are based on eligibility. So it sounds like it's having the right effect. I wonder though, where's the gap? Because I think there's been 3.3-ish million applications done so far. Where's the gap between that number and what's left? And because that will then presumably help with where the grants need to be targeted in the future.
Well, that's a good question. I think we would all like to know how many people is being left out of the scheme so far. However, having said that, I think more important is the question: who are those people who need support, rather than how many of them there are. There is a very clear pattern in terms of how grant-funded organizations have been supporting users to access the scheme. So the first sort of batch of users that were supported tended to be people with medium support needs, people who just needed a bit of confidence, they needed some help with documents, maybe evidence, and so on. As we moved on, the cases have become more complex, more difficult, which shows, I think, that people whom we need to help most in this later part of the application window for settled status will be clients who will have quite complex legal advice needs. There will be less maybe clients, but those needs will be much more complex. We are looking at things like cross-border criminality. So, for example, people having convictions in other states, member states, and needing to deal with that to be spent, for example. There will be issues with family breakdowns. There will be issues with domestic violence. There will be issues with derivative rights. Those things that will require much more advanced, much higher level, because it's left sort of tiered immigration advice. And I think that for this reason, we probably would need to focus on the quality of that advice rather than sort of the spread of net.
So going for, rather than breadth of trying to cover everything,
Yes.
essentially narrowing it down and saying what's left is essentially the more complex cases. Yes. Kuba, sorry, I think you wanted to come in.
Thank you. I just wanted to come in on those figures and the number of 3.5 million people who applied, and just really stress that, first of all, the way the Home Office reports on those figures means that it's the number of applications rather than unique applicants that is being reported on. Applicants can submit multiple applications to the EU settlement scheme when they want to upgrade from pre-settled to settled status. The Home Office currently says it's only about 2% of all applications that are duplicate applications, but that would mean around 70,000 already in the system. Secondly, from that 3.5 million people, we are not quite sure how many of them are still in the UK. So even using that figure as the number that is certain is slightly problematic. And then the biggest problem is obviously that we do not know how many EU citizens are here. I'm looking at the impact assessment for the EU settlement scheme produced by the Home Office in March 2019, and that states that it's anywhere between 3.5 and 4.1 million. So even the Home Office admits that there is the gap of uncertainty around 600,000 people. And since that was published, we learned that there are further problems with the reliability of the population statistics that these numbers are based on. So it's very, very hard to estimate both the numbers of people that are, well, it's impossible actually to estimate who and how many people are yet to apply.
Yeah, I think that's a good point. I think that's why it's so important. The next bit of the grants is targeted on, where we're missing gaps. Barbara, I know you wanted to come back, but I think Luke wanted to come in.
I would just look before just one word on counting people in this context. We have quite significant interest from EU nationals who have returned to EU member states, but they have retained right of residency, and they can still apply for those to use this immigration instrument. So on top of EU nationals actually living in the UK, you have significant number of EU nationals already departed from UK who might wish to either retain their connection with the country because of children, whatever, parents living here, or they just want to come back. So that's additional thousands of people that we might need to consider as clients for this particular scheme. Thank you.
Just a very quick point. Those applicants that Barbara is talking about, they're also counted towards the figure of 3.5 million applicants. So just because there were 3.5 million applicants doesn't mean that they were all based in the UK. It's possible to apply from overseas, and people indeed have. Those figures are rolled into the totals.
Luke, did you want to come in?
Yeah, sure. So I believe your specific inquiry was around the grant-funded organisations, and I agree that I think that is quite an important limb in this process. The feedback that has been given to me and to others has been quite mixed. And I know that there are some organisations who feel that the investment of time isn't exactly reflected in the way that the programme works. It's not commercially viable for those organisations. There's also been some concerns that I've heard from some organisations who haven't felt that they've been able to put in new applications because it isn't going to be sustainable for them to be able to do so in the way that the grant funding has been set up. I think there's also been some concerns expressed about the way that information is being fed back. These organisations often exist in their silos of experience. So if they're specifically dealing with children, they know their expertise and so on and so forth. There hasn't, well, at least to me, there hasn't been a global sort of perspective that's been disclosed from the Home Office in terms of how they're mapping which organisations and which resources need to be delegated in the correct way. I think what is clear is that these organisations, some of them have freshly established themselves, but most of them have existed already. If they're being discouraged from providing this service, particularly as the need is going to grow over the next 12 months, it's going to expose some quite significant gaps in support for the people that we are most concerned about, which are the ones that are going to be left behind. So I think there's some very serious questions that need to be asked in terms of the operation of GFOs, their funding, and actually listening to them more and understanding what more can be done to provide them with the necessary support to take their work forward over the next vital 12 to 24 months.
Okay, thank you.
Okay, thank you very much indeed. Now, returning to Nigel Mills.
Try again, can you hear me?
Yeah, we can hear you now, that's great.
So we heard last week that the European Commission thought the rights under the Withdrawal Agreement were roughly similar to free movement as it currently exists. Do the panel agree with that? Do they think there are any gaps that need to try and be fixed as part of the future relationship discussions? Who wants to start? Barbara, do you want to?
No. I will pass on the question. I need to think about it. Hold on.
Yes, I'll do my best, Nigel. I think the challenges that particularly the gaps in terms of what EU citizens in the UK have compared with British citizens in the EU, it's quite a different story. A lot of it is about the ongoing and the future relationships, particularly around issues relating to social security coordination, professional qualifications, and there is a sort of lacuna, if you like, in terms of how that is going to work going forward, particularly on, for example, professional qualifications. We've had reports given to us by experts in certain areas, for example, lawyers, who have a qualification that's currently recognised in the UK, and they're unable to be sure that their qualification is going to be recognised in the future, because it's conditional on the future negotiation and what's going on there. In terms of broader freedom of movement rights, EU citizens can move back to the EU, but there are barriers that would prevent them from coming back to the UK in the future. So, for example, a EU citizen with settled status, they wouldn't, if they were outside the UK for 5 years, they wouldn't be able to return relying on their rights under the agreement. But which, 5 years is a long time, but I think where it's more contentious and more problematic is those with pre-settled status. If they are absent from the UK for a period of 6 months out of 12 months, they break their continuity of residence, which would therefore prevent them from qualifying for settled status in the future. So there's some real concerns there about how people will be protecting their existing rights with a view to securing their more permanent rights in the future.
Okay. Kuba, anything to add? Or
Yeah, I think saying roughly similar is one of multiple ways of saying that things are actually different. And Luke pointed out to some of those differences. I just wanted to add one point around the mechanics of how the settled status works. You didn't have to make an application to be in the UK under free movement. So this is a fundamental change that we really need to understand. And then the second thing that follows from that is the mechanics of how the EU settlement scheme then works, and all those concerns that we've already mentioned related to the digital status and how it tracks every interaction with the with the state in the UK for EU citizens here. So even if people are allowed to stay, the terms on which they're staying are quite substantially different.
Presumably, it's fair to say that these are the rules now, and the rules on if you are out of the country for more than 6 months, you could lose your entitlement. That's not going to change as part of the future relationship negotiation, is it? The rules on professional qualifications being recognised might do if we get a good deal, I suppose. Luke,
yeah. I think that's a fair point. I think there is there's two sorts of points really, I suppose, that come from this. When we say there's a question as to whether or not the rights under the withdrawal agreement are the same as existing rights under EU law now. The problem is that the way that rights are being implemented in the UK is being done in a way that's never been done before under EU law. So the constitutive model is not something that's ever existed within an EU legal framework. So there are particular novelties in the withdrawal agreement that haven't exactly been explored before. So there's a sort of fresh ground in that sense. And then there's the elements of what the agreement of leaves behind, which are the things that we've just been talking about here, which are conditional on those future arrangements and agreements. I think the thing with the way that EU law works in an abstract sense is that it's on a rolling basis. You know, if you break your continuity of residence, you could just go back into the member state and start it over again. But under the context of the withdrawal agreement, it's a frozen point in time. It's not something that has that sort of refreshing basis. So I think at this moment in time, we are still very much sort of seeing the consequences and the effect of having this new way of seeing rights being preserved under the withdrawal agreement. And I think as time goes by, we're going to start seeing some divergences legally and practically between how existing EU law works and how rights under the withdrawal agreement work. And I don't think we're really going to see that until, probably next 6 to 12 months.
A slightly separate matter. I think the 3 million asked to be an observer at the joint committee meetings, and we haven't met with an entirely overwhelmingly positive response for that. Can you just explain perhaps what you thought you might gain from being able to be an observer at the relevant meetings of perhaps their subcommittee, and what the latest status is?
So I think it's important to have a voice in the room that is speaking for those who are in scope of the withdrawal agreement. It's not as though it's, that we're talking about an agreement that essentially looks to protect the rights of people, and people's experience and people's voice, I think, is important in that. So that's the sort of abstract point. More specifically, there has to be a translation between the experience and the impact of the agreement, and then that being reflected in the discussions that are had at these committees. It's fine. It's great that we can feed into that through written evidence and potentially being called to give evidence to those particular entities. But if there's a permanent presence, it allows for a much clearer, stronger dialogue between the organisations that are discussing with other organisations the experiences and the problems that EU citizens are having, and then bringing them to the table so that they can be discussed in a frank and open way. It's also seeing it from a non-partisan perspective. Our objective is to ensure that people who are in scope get their rights and they're able to enforce them. And I think it's important that those that represent those people have a voice in those discussions.
And are they giving you any encouraging noises that you might be allowed in the room, or is that not the case?
We've had some positive discussions with the for parties about feeding into it, but in terms of our status and actual physical, what we've asked for, that hasn't been a flat no, but it's diplomacy. So
but you aren't getting an invite, so that's basically a no, at least for now. Okay, thank you.
Okay, thank you very much. Next, we turn to Peter Bone. Peter.
Thank you, Mr. Chairman. And can I start with Kuba, because it seems to me that you regard, well, lies, damn lies, and statistics seems to be where you're coming from in relation to perhaps the Home Office and the ONS on statistics. What do you think about their statistics?
Well, I have a lot of respect for the ONS statistics as such. I think the ONS is doing great job in terms of the remit. The problem is not so much how well the ONS is working, but what the data is used for. It's the data on EU population, EU citizens population in the UK was never collected with something like a constitutive EU settlement scheme in mind. It was never meant to be precise enough to allow for exact monitoring how many of those in the country applied. Most countries in the EU, as you have heard, I think last week from our friends British in Europe, will have some sort of registration system for UK citizens and any EU citizens exercising free movement rights. The UK has never had such a system. So the ONS statistics are very helpful, but they're not good or not granular enough to precisely monitor what's going on in terms of the uptake of the EU settlement scheme. And some of that is currently being improved by the ONS. They're making improvements to 2021 census, which is great, but it will be too late to actually have any bearing on, because it will be the results won't be known until past the EU settlement scheme deadline. But there is still a problem, even if these were perfect statistics, there is still a problem that they're based on survey research. It doesn't cover all the types of EU citizens here. There is a year of difference between the publishing of the stats and the point where data was collected. So it just cannot be precise enough. With regards to the Home Office statistics, again, I think they're very helpful, and we really appreciate the Home Office putting out quite a lot of information out there. But there are those fundamental problems, such as the lack of clarity over the number of applicants that actually applied to the system. And then there are some specific issues which we think the Home Office could be reporting on, and it isn't. And probably the prime example there is reporting on gender. In terms of application numbers and application outcomes, we do have concerns around the quality of status being granted to women in particular, because they obviously have still more caring responsibilities than men. They're less likely to be in continuous employment. And seeing data on gender would allow us to see if there's any disparity there, but the Home Office is not publishing that data.
So in that particular case, it's not that they don't have the statistics, but they're just not presenting the right statistics, or maybe deliberately not presenting the right statistics. That is something the Home Office could improve. Is that your view?
Yes, and I appreciate there are a lot of technical issues there. So I wouldn't go as far as say deliberately. But the ICI, the Chief Inspectors for Borders and Immigration report from September last year has shown that data on gender indeed is available in the EU settlement scheme system. It's just not being reported on. We had a freedom of information request around that, and that was refused. But that doesn't quite tally with what we know from the Independent Chief Inspector's report. It seems that data is available, just not reported on.
So if I had to ask you to be reasonably precise, what is your estimate of the number of EU citizens in the UK, and whether they're likely to all secure their rights? And we've learned earlier on that there are also EU citizens not in the UK at the moment, but have some right to apply here, which did rather surprise me. I would have thought if you rather had to be in this country to apply. But could you first of all give us your best number and split it between how many are actually here and how many are actually in the EU, if you don't mind.
I absolutely do not mind the question, but my best professional opinion is that it's just not possible to say. And I think this is the problem that has to be fundamentally recognized. And this is the reason why the 3 million has been calling for a declaratory system, because on the 31st of December 2020, we don't know. We can't possibly know how many people will be in the UK in 6 months' time. It depends on people coming in and going. And I think what the kind of the statistics to date released show us is that some of our estimates were very wrong. Probably the best case is the example of Bulgarian citizens. The most recent ONS estimate is 121,000, and yet there have been 179,000 applications from Bulgarian citizens. So it seems that every Bulgarian citizen in the UK put in 1.5 applications through the settlement scheme system by now. With data this imprecise, I just couldn't possibly give you an estimate. I would call for an approach that does incorporate dealing with that uncertainty rather than trying to guess the best number.
Yeah, I sort of remember during the referendum campaign, in fact, I think clashed with people from your organisation over numbers. Were you called 3 million because you thought there were 3 million EU citizens in this country?
We were not active during the referendum campaign. The 3 million campaign started about a month after. The first meeting was about a month after the referendum. So we had no, as individuals, perhaps, yes, but as the 3 million organization, we had no role in EU referendum campaign. We didn't exist at the time. The name the 3 million is, I mean, we could, citing the Home Office numbers, call ourselves low estimate 3.5 million and high estimate 4.1 million, but it wouldn't be quite as catchy. We went with the 3 million as a kind of a symbolic figure, but we would not advocate using it as basis for making policy and as basis for developing administrative systems.
No. What I was just trying to get at, the difficulty with getting the statistics right, because obviously, you know, if I was in your case and actually thought there was possibly more than 4 million, I'd have said 4 million. It does seem that there's been real difficulty on this. You did touch on the fact that you weren't sure whether, in fact, the number of EU citizens in this country would go up or down before the deadline. What is your sort of gut feeling on it? Or will it be this? Will the numbers say the same but different people, if you see what I mean?
The most recent figures, and again, uncertain as they are, show that there is still a small dribble of EU citizens into the country. So the most recent estimate is slightly higher for the year ending December 2019 than for the year ending December 2018. So there is still a very, very tiny inflow, it seems. But then again, it breaks down between different groups. You know, accession aid countries, nationals seem to be perhaps moving out in higher numbers than the old EU countries. So there is quite a lot of movement within the group of the cohort of EU citizens overall.
Do you think as we get closer, there'll be a sort of rush to come here from the EU?
I don't think there is any evidence right now to suggest that, no. I mean, why, even if people wanted to arrive to secure their status, I'm not sure why they would be arriving minutes before the deadline. So I don't think that necessarily is something that would happen. And from most European countries, it's extremely hard to come to the UK now anyway, because of COVID.
Yes, I mean, I think maybe that's one of the reasons I said that question, because obviously people who might have been planning to come this year wouldn't have been able to because of COVID. And assuming that we sort of get to September and things are more back to normal, you don't think there would be a particular rush of people coming in then?
I mean, it's hard to find data to make this prediction on. I would say that there is no indication right now, but you raised quite an important point there, which we are concerned around EU students coming in to the UK for this academic year, because this is the last year when EU students are eligible for home fees, and there is a slight concern how that will be impacted by COVID, because every year there is a substantial number of young EU citizens coming to study in the UK. But these, yeah, I would say that my best answer to that would be to say that there is no data to indicate that there is any large inflow of EU citizens into the UK to secure status before the end of December 2020.
Thank you, Chairman.
Okay, thank you very much indeed, Peter. We now turn to Sally Ann Hart. Sally Ann.
Good morning, thank you, Chair, and good morning to our witnesses. I'm just going to ask a bit about some of the more vulnerable people, EU citizens living here with children in care first. There are around about 9,000 children and young people in care in the UK, and the local authorities have a duty of care to these children and a duty of care to make applications for settled status for them. According to 3 million figures, so your figures, only about 11% of these children have secured settled status. So to go to Luke Piper first, what more could be done to ensure that children in care can secure settled status in time?
Thank you. I think there's a lot of reports out there, not just from us, but other organisations like the Children's Society and Quorum, who recently published quite a detailed report on the sorts of recommendations and things that should be put in place to assist particularly vulnerable children in care. There is quite, I would say, one of the headline things is the provision of resources and information to both local authorities who have the legal duty, but also to civil society organisations who can provide the help with the application process. It's not uncommon for a busy social worker to not really understand the full extent of the rights and options that are available to children in care. It's not just about exploring their options to apply for status, say under the settlement scheme. There may be options and strict deadlines for children to become British, registered to become British, for example. So there is a clear need for quite broad service and support to those agencies. There was a lot of call for some actual legal frameworks to be put in place to protect particularly this vulnerable cohort of children. That took the form of an amendment to the I won't get the full title, but the immigration bill that's just now been passed to the Lords, where there was encouragement for an automatic grant of indefinitely to remain settled status to children in this situation because of the vulnerabilities that are associated with that. I won't labour the other points of the report, but I would strongly recommend that the Quorum report and indeed the observations from Children's Society are looked into. Much of the observations there I would particularly support, particularly around the increased provision, but also recognising that there does need to be clearer guidance and information given to Home Office staff about how to deal with these cases, particularly as far as evidence is concerned. There is quite a clear problem with children, particularly nationalities, unable to acquire identity documents. And there have been some concerns expressed about how those people will make applications and then they will be able to navigate to get the appropriate status. So yeah, there's the key points that I would make on that issue.
Thank you. So the low success rate for applications for children in care is to do with resources available, but also these could, if local authorities or the government looked at the Children's Society and the Quorum report, it might have some recommendations in order to improve those success rates.
I think just to kind of unpack that information that you've set out there, it's not necessarily the number of successful applications versus unsuccessful applications. It's a question of people who have yet to apply. I think one of the major issues, much like the statistics more generally about the EU citizen population, is that we don't actually know the number of children who are in care and are looked after children by the local authority. So there is an internal mapping process that a lot of these organisations have to do anyway to identify these particular children and cohorts to then get them to the status that they need. I think the challenge is educating and resourcing the people who have that legal responsibility and ensuring that they have the sufficient power and information to be able to then support that child through the process to the appropriate outcome. Because otherwise the consequences could be quite dire. Yeah.
Okay, thank you for that. Barbara Drozdowicz, you want to come in?
Yes, just quickly also from our experience as a support organization has been that children in care can be quite misleading term, because those children can be 16-year-old and have criminal convictions, for example, quite a few behind their belt, partially because of coming from disadvantaged backgrounds, for example, partially because of such as life. Our experience in supporting children and or in particular social workers who have to support those children in accessing settled status is a mixed bag of goods, to say the least. We have seen some quite dreadful mistakes made in terms of how applications were put together by social workers, because social workers are not immigration advisors and they shouldn't be put in a situation when they have to solve the complex immigration case for a client who might be 12-year-old, might have already cautions, maybe some convictions, where there are no ID documents, when the member states will not allow for ID document to be released for a child because due to national circumstances. So some countries don't recognize paternal sort of responsibilities of councils because they are not the member state councils. So it is quite mind-boggling sometimes, this particular user group. Obviously there is an issue of consent for application to be submitted on behalf of the child and so on. So I would say that it is also a matter of quality of support that these children and young people receive, and this is something that really worries us at this stage of application window, which is only a year to go. First, the ability to identify EU national young people and children and identify the fact that those children need to be supported in accessing the EU settlement scheme, ability to identify complexity of those cases and refer those children, young people, together with the social workers supporting them to appropriate immigration advisors, be it places like Coram, for example, Children's Law Center, or other providers who are able to provide level 1 to immigration advice, which would be probably most of the times for complex cases of EU nationals. Finally, ability to collect or reissue documentation that these children will require, because obviously evidencing stay is not something that is easy to do, even for children who have been in care for quite a few years. But the way how their origin in UK or ability for social workers to understand where these children are coming from in the most literal term is also an issue. So there is a lot of barriers why the young people will not be supported, and I think that 12 months is not enough to identify them all, let alone have them supported. But it is the case also, I will mention here, speaking of vulnerable people, with people who have limited capability to perform legal duties. So for example, people with mental health issues, sectioned people, older people who have dementia, onset of dementia, for example, or other kind of learning incapacity. Also, this is a group that we struggle with because there is also a legal aspect of submitting application on behalf of people who might not
lack capacity.
There is an issue of criminal activity, criminal past, for example, that people might not want to disclose, even in our best intention to help them with EU settled scheme. Obviously, we have to recognize their actual desire to have this application put in. So there is and that will be also the case obviously with young people. So it's very long process, very complex process that is kind of multi-layered. And I don't think that 12 months we have is enough for community to support members in application, especially those cases where it is, as I said, so complicated to provide support system, just to plan out the case.
Thank you, Barbara. And I know you've mentioned the elderly, but Dr. Jablonowski also, Kuba, mentioned elderly people beforehand as well. And we do obviously have a number of elderly people who are vulnerable. They're going to remain vulnerable. They might be in care homes in this country. So what is being done to help these people secure settled status? Kuba, do you want to answer that first?
So there are, as part of the grant-funded organizations, there are organizations that specifically deal with that issue, and I think Age UK is the largest one, which is trying to support elderly applicants, but not exclusively, because that's also done. I'm pretty sure East European Resource Centre is on that. We know that our colleague from the 3 million who works for an Italian organization, they do support a lot of elderly applicants. So a lot of organizations do outreach with elderly people. I think the main problem is how to reach those who are socially isolated, and there isn't an easy way out of it. Care homes probably can be dealt with in some sort of structural way, but people living on their own, that's probably those we would be concerned the most about. The other concern that we had around elderly applicants was that we, especially towards the end of last year, I think we saw a large number of those people who have been here for decades being granted or being offered pre-settled status rather than settled. So it's not only about them knowing about the settlement scheme, but also knowing what status that they should be getting, and making sure that they don't accept lesser status. And if they do, that they know that they need to reapply to the scheme further down the line. So there is a few things that could be done, but I think there is still an element of uncertainty there and not being able to reach everyone in time. Yeah, okay. I'm afraid.
Thank you, Kuba. I know Barbara put her hand up, and then Luke.
Just very last quick word in the issue of being British citizen, because this is another issue that is sort of coming into play in applications for settled status. It is the case with both older and young people and children, because some children are British citizens, technically speaking. They were born in the context where parents were residents already and with a long enough stay and so on. So some applications we have been dealing with who have children in care or children actually were rejected simply because Home Office recognized them being British. This is the case that we struggle with older people in particular, because older people quite often might have sort of sense belief that they are British, and there is no documentation to support it, but there is also no reason to believe that they are not, because people might not have documentation as in passport, because they've never used passports, for example. They never traveled, they never needed it. So with both groups, and in particular older people, it is also the case of this identification whether the British citizenship has already happened or has been documented or not necessarily. And this is something that in these particular two groups is important to be aware of, and also to be aware to provide support to both clients, but also organizations that might have clients, including that would include social services, for example, that will have clients who might be British already, and just kind of follow that path, because that might be easier actually with some of our users. That has been the case. And I think it's only fair for people who have become British citizens to give them rights to exercise that law right.
Okay, thank you. Luke.
Yeah, I think there are obviously very specific groups with acute specific problems, particularly with older people. The use of technology is more often the biggest hurdle. Age UK did publish a small report at the end of last year where they set out that over a quarter of over 65s have not used the internet in the last 3 months. So there's a real concern about barrier, not just to the application process itself, but then going on to proving their rights in the future. As far as those that have ill mental health issues relating with capacity and so forth, there are some very significant legal barriers to people who are able to apply on behalf of that person, and the legal measures that have to be put in place for that person's application to be submitted. If somebody is fortunate enough to have a power of attorney, and the scope of that power of attorney does include the ability to make that application on behalf of that person, then that's great. Otherwise, there are, as I understand, some quite significant legal barriers that people would have to go through to be able to have somebody who can apply on their behalf. I think the unifying element of particularly vulnerable groups, I mean, there are a lot more beyond children and adults, but the unifying element is the concern about missing the deadline next year, and the consequences for not applying in time are quite significant. Not to labour the point, but just to kind of really revisit the significance of it, is that if you do not apply by the deadline, the rights that you had before will disappear. And if you don't have new rights, you essentially are living in the UK unlawfully, which would mean that you wouldn't be able to work, access housing, very much wouldn't be able to access the NHS and other vital services until you acquire a status. So one of the unifying questions that needs to be answered and have quite a detailed understanding of, and this is consistent across sectors, is who can apply late, who can apply after the deadline, and what their rights will be until a decision is made. I understand the government's anxiety to be too prescriptive in saying who can apply late. I understand that. I think what would be helpful is if the government were to explain who should not be able to apply after the deadline. A lot has been discussed about those who can, but there's not been a lot of discussion about who can't. And I think if we can have a clearer discussion with the Home Office, and that's something that we can have now, it's something that the organisations like ours and others can start preparing work on the ground to be able to say, look, if you're one of these people, you better apply before the deadline, otherwise you're in quite a lot of trouble. So that's a big unifying question, is the reasonable grounds issue. But specifically, just looping back to older people, I do have concerns about the numbers of, we don't actually seem to have a clear picture, again, about those who are entitled and those that can and do need to apply. I think it's more likely than not, based on my own experience, that older people are more likely to have an assumption that they have a right to be here than, say, somebody else. But I would say that there is a very concerning trend, and this steps beyond vulnerable categories into more general EU population, is that there is a worrying perception by some people that they don't need to do anything. I regularly come across people who have previously applied for and acquired permanent residence documents thinking that that's the end of the journey, they don't need to do anything else, or that they've been told by somebody that they're British and they don't need to worry about it, or they have this perception that they've lived here all their life and they don't need to do anything. And there are very similar trends here in the assumption of rights to those who were impacted by the Windrush scandal. There was this continuing assumption that they were okay, and then when they faced those barriers of employment, housing, health, it was only at that stage then that they realised that they weren't safe. And unfortunately, sometimes it's too late then, and it could take time for them to then be able to retrospectively fix the damage that's been done.
Okay.
Thank you.
Thank you very much indeed. We now turn to Philippa Whitford. Philippa.
Thank you very much, Chair. If I could start with the issue of there not being a physical document and it only being online documentation. You mentioned the survey, I think it was yourself, Luke, that 89% of EU citizens are concerned about that. Now, obviously, it creates a barrier in certain circumstances, but obviously, even if you needed it quickly, you can't access the internet everywhere in the UK at any moment that you would want. So what are the arguments put forward for why there shouldn't be an ID card, and in what way do you not agree or not accept whatever the argument is of the UK government for not having a simple ID card that comes out at the end of this?
Shall I start, or Kuba, would you like to go first? Kuba, you mentioned the statistic, so if you would like to go before me, that would be great.
Right. Yes. Okay. Thank you. Yes, I did mention the statistic. 89% of people in our survey said they would like the option of a physical document. I think it may be actually Luke who will be able to add a bit of background why the Home Office is insisting on this being digital only. My understanding is that aside from the more utilitarian things that the EU settlement scheme is doing, it is also a bit of a testing ground for the future immigration system, and that system is meant to be digital. So I think that's one of the reasons. The official explanation is around creating a double two-tier system where some people have online status and some people have physical document, because our position is that the physical document should be optional, it shouldn't be compulsory. So the kind of the two systems explanation is the more charitable one. The less charitable one is that it is meant to test how an online only system behaves in practice. The obvious caveat to that is that the online system is still linked with a physical document that the person used to apply to the EU settlement scheme. So it isn't only digital. You need to have that ID. If you change your ID, you have to change your ID with the online system. So there's still a physical element to it.
Luke?
Yes. So the reason that's communicated to us repeatedly of why things need to be digital only are, in the large, that a digital status is more secure and it is essentially a safer means of proving your status. What I would say to that, in addition to what you just said there, Philippa, about the ability to access that status, is that digital statuses, as much as we would love for them to be 100% secure, are hackable and are subject to sometimes erroneous changes. And we have had reports from people where their photograph on their digital-only status has been changed without them knowing. And I think the main thing to be said here is that digital technology is obviously fantastic, but we are essentially seeing a transitioning here from a tried and tested system of people just having their passports or a document. And it's taken many years for employers and just the general public to familiarize themselves with these documents. Essentially what we'd be seeing is a shift, a seismic shift from that to a digital-only platform, which requires multiple steps to be able to access the status. And that's going to happen in a very, very short period of time. Essentially, the transition for that is the grace period next year, which is 6 months. And it's not a small population of people that who are going to be having these to go around and prove their digital-only status. It's millions of people that we're talking about here. And it's quite concerning, essentially, that there is a guinea pig sort of untested trial going on here to EU citizens. And we have a couple of briefing documents which we'll be happy to circulate, where we address in more detail the concerns around a digital-only status and this vast shift from one status to the other. I think it's worth mentioning that we hope that the government will revisit this discussion, because it's more so about people having the opportunity to have an alternative. You know, we must drive towards secure, safe, and a better way of doing digital status. And there are problems with the way that data is managed. That's a sub issue, if you like, of having a digital status, which we could revisit. But people want and arguably need a physical document. And the Right Honourable Michael Gove said before the House of Lords European Union Select Committee recently that he understood there was a moral and social case for physical documents, and that it's something that remains stronger as ever. And we do hope that, given that there seems to be some wind in the sails, if you like, around this issue, that it's something that the government will rethink and revisit.
Okay, thank you. Obviously, as well as we've already talked about the sections of the population who do not have easy access or understanding of the internet, I think the Windrush scandal has definitely left people with a feeling of vulnerability if they don't have something locked away in their house and in their hand. Barbara, you wanted to come in.
Yes, I mean, in terms of the safety and security of the system, sort of the online profile being in principle more safe than actually having your documents snatched from you, because that's also one of the arguments that in terms of literal safety of the document and status, the Home Office did mention in the past that one of the reasons why they insist on online product is that it doesn't expire, which is flawed because it is attached, as Kuba mentioned, to actual passport that does expire. So what's the difference really? But it is about, well, if no one can snatch it away from you and use it in kind of wrongfully and sort of abusively against you, sort of exploiting your status. Well, they can, and they do. We have very significant and very disturbing number of clients who come to us for aftercare, for lack of a better word. So people who already have status, and then they discover that either they cannot access it because someone changed the login details. Login details are multiple, so you need to have phone number and you have to have the password that is attached to email. These are the details that you give to Home Office, so to speak, to the system at the stage of application. So unfortunately, we have a number of clients who have been helped by unregulated immigration advisors who fleece them, to be honest, in terms of how much they charge people for it, but then they retained the details of login details to access the online profile. The question is how much they charge them follow on to send the link to the employer. So there is always a way, if there is a will, unfortunately. If there was an ability for users to have optional physical document, a card, that gives additional layer of safety, because you become independent from criminal networks that surely will try to take over and sort of hijack the agenda here. I am positive of it because it has been the case already. It seems so. It's more opportunistic now, but time will show how people can be smart when it comes to the online systems and taking them over, not even hacking them in literal sense, as in accessing sort of the actual online product, but just taking over the access to that product. And in terms of older people in particular, I would be very worried that this is going to be literally what is going to happen, and that profile will be used in future to claim benefits on, for example. So there, if we could ask for one thing, that would be that additional option for clients to have a document.
Physical document. Kuba, can I start with you? Obviously, we touched also on the fact that the government statistics show about 40% of people are only being granted pre-settled status. And certainly my experience of constituents is this is also including people who've actually been here for many, many years, of course, never expected to have to apply for something, so don't have all the documentation. And they're for people with caring gaps, employment gaps, which still in our 21st century predominantly affects women. How concerned are you about this? And with regards claiming things like benefits and other rights that come from your status in the UK, what impacts are you seeing on settled status, pre-settled status, and those who haven't applied yet? And I'll come to Barbara and Luke on the same question.
Well, thank you for that question. I think it is hugely important. And just one point of clarification, it's not even people getting the wrong status, that people being aware that they were granted the wrong status where it begins, because the highest number of reported cases of people being granted the wrong status, we saw that at the 3 million when we publicized a table showing the difference between settled and pre-settled status. And then suddenly we had a flurry of emails, people contacting us and saying, oh, hang on, I do have pre-settled status. I didn't realize it was worse. I've been here for years. And one example that stayed with me, because we talk about those groups of vulnerable applicants here. One example that stayed with me was a person who was a dual Australian and Greek citizen, born in Australia, 100% fluent in English, obviously with a slightly different accent. And he worked for over 20 years in civil service. So hardly somebody who you describe as vulnerable. And he contacted us saying that he accepted pre-settled status without knowing the difference, despite decades of residence in the UK. So some people may have the wrong status and not even know. As for the ratio of pre-settled grants, that's now 41%. And yes, we are numerically, we are concerned about this. My favorite document today is that impact assessment from 2019 that the Home Office produced. The low estimate for all pre-settled grants in that document was 900,000. The high estimate was 1.4 million. We're currently over 1.3 million. So it will probably take a month or two before we go over the high estimate of what the Home Office thought would be reasonable to expect in terms of pre-settled status grants. It is impossible to quantify how many people were granted wrongly. We've seen numerous cases at the 3 million. We also have seen cases where such applicants given wrong status were willing to speak to the media. Again, one case that I remember from the top of my head was somebody whose case was publicized on Monday, and the Home Office was calling him to tell him that his status got upgraded with no question asked by Wednesday. So it literally took 3 days for him to get upgraded without him doing anything. But the ICIBI, the Independent Chief Inspectors report that I mentioned, where the inspection window was very short. It was only 3 months between between April and July last year. It showed that there were more than 7,000 people who selected the option of getting settled status, but ended up on pre-settled status. So it is really hard to tell. It's anyone's guess, but we know this is happening, and we know the consequences are very serious, and we know that some people do not even realize that they're in that situation of having accepted the wrong status.
So some of it is people not understanding the difference. What they're thinking is, if I get pre-settled status, in a couple of years it'll be settled status. And even, as you touched on, the ability maybe to go home and care for an elderly parent for longer than 6 months, or accessing benefits, or what happens when we get to the end of their pre-settled time. So do you feel there's a need for basically a campaign to at least get people to understand the difference between settled and pre-settled status?
Definitely. I mean, some of that has been done already. I can see Barbara nodding her head. I'm sure she tells her clients on a daily basis. We raise awareness of that with the 3 million. But as you said, it's not something that people instinctively think about. We also need to understand that Europeans who are arriving here were arriving with no expectations of any border immigration controls being imposed on them later on, and it's not intuitive for them to be thinking about this even now. So the kind of knowing that you have to apply for the status is the first barrier, but actually understanding what the status is and what it involves is another. If you don't realize what are the limitations of pre-settled status, the question has to be asked, will you know that you need to reapply in order to secure your rights in the long term? So there's lots and lots of problems, and obviously COVID exacerbated that, because if somebody on pre-settled status has left the country, for example, going for winter to their home country somewhere in Southern Europe to enjoy the sunshine, and then they got locked down, say in Spain, they may be coming back now with their pre-settled, with their continuous residency reset because of the 6-month absence. So.
We're running short of time. I don't know whether there's any comments that Barbara or Luke feel they would want to add, both of you. But short, please, because we've still more questions.
Yes, just very quickly, just a point that Kuba did mention already, sort of signaled there, is the fact that people will have to reapply to apply for settled status. And what worries me very, very much is that people will not know when this moment will come, because hardly anyone is really mapping out their life against the immigration status. This is not how life kind of works, really. But the other thing is that whether there will be support in the 5 years' time for people to apply for it, and we are talking again about vulnerable groups, young people, older people, and people who might have very, very stretched history in UK. Let's not forget that people who left the UK as late as early as 2011 are still eligible to have settled status full on. These people will not necessarily know what to do. I mean, if they decide to re-engage with the UK and so on. So whether there is going to be support for the pre-settled status clients currently later on will stretch 2026 is a big question mark that I would like to ask for to make the support available.
Okay, thank you. Luke, just very briefly.
Well, I promise. I think it's important that the rights associated with the status really do need to be communicated, particularly in relation to accessing housing and social security like universal credit. It's one thing to get the status, that's fine, but the real problems start when people are trying to exercise their right. There's a big difference between what you get with just settled status and what you get with pre-settled status, and that's been acutely felt during the COVID crisis. And I think a lot of members like yourself are going to see that balloon as the economic crisis continues.
Thank you.
Okay, right. Thank you very much indeed. Next to Barry Shearman. Barry, over to you.
Chair, thank you so much. I have learned so much from our excellent witnesses this morning that I'm quite humbled. When I worked for a living, before I became a member of Parliament, I was an academic and I was a social scientist. And I understand that a lot of the stuff that we've been discussing this morning has been technical and it has been based on data. And I apologise that the British government is not very good at data. We don't even know where people die and what they die of, by and large, let alone how many people we're talking about this morning. But could we delve a little bit below the stats? Could I ask the witnesses, what's their feel of the kind of sense that these 3 million very valuable people working and living in this country, you know, some are key workers in the NHS, others are very skilled workers in the agricultural sector, are very valuable. What are they thinking about the process? What is the morale of the people that you are interviewing, talking to? Can you give me any sense of that?
Yes, I think we can, Barry. Kuba previously mentioned some research that Tanya Budman had done, and a big part of her research was exactly on this. And I'm looking at right now at the word sort of graph thing that, you know, strikes popular words of how people have been feeling about the scheme. And what strikes to me are words like angry, anxious, alienated, annoyed, unwanted, upset, unwelcome. And I would say that for the vast majority of people that I know, one thing that Brexit did do was to galvanise an EU citizen identity. But what we have seen there is that whilst that's a positive thing, the community has come together and people have, you know, rallied together to support one another, there has been this pooling as well of those feelings that I've just described to you. And I think anxiety is definitely the biggest word on here that I can see, and I would agree with that.
Thank you for that. Anybody else like to come in on that one?
I'll just mention quickly that it is.
Can I call you Barbara for shorthand?
Yes, of course. It is all that Luke did mention. We agree, but also, I mean, there is an element. I mean, in terms of our user group, our users are disadvantaged, marginalized. they sort of struggle. This is our mission as an organization, not a selection for this particular project. It has been, however, there is a sign of people just basically doing submitting applications because this is something that is expected of them without over analyzing the fact. There is also a group of people who acquired rights under US says that they wouldn't have under EU-based sort of legislation-based permanent residency regulations. So people who don't have, who wouldn't exercise treaty rights for various reasons, or who would have problem with evidencing exercise of treaty rights. And those clients obviously do appreciate settled status as a process. They also appreciate, quite a few of them, especially those who vulnerable ones who have been accessing state support, such as, for example, social housing or benefits, and have had bumpy ride in that process by being taken off due to sort of on the face of it in ineligibility, and then taken back on because actually eligibility was there, and then taken off again, and very complicated, difficult, sort of very anxious times for lots of vulnerable people. They do appreciate the fact that settled status do give them this solid kind of evidence base that actually they can apply for something and they shouldn't be removed from social housing because it seems that someone misinterpreted what exercising treaty rights is, for example, or whether there are retained worker rights or some other horrible words that people don't really understand and cannot apply. So that there is that, and there is also some.
Can I push you a little bit on that? Just on that particular point before we move off it. These people we're talking about are deeply embedded in our neighbourhoods. They have family, friends, neighbours. They have schools, teachers. Are they getting that support from, I would imagine, that community when they're distressed or uncertain about the processes that they're facing? Are they getting that, do you think?
Well, to a certain extent, yes, and also they do. People rely on organizations, charities such as like mine or local CAVs, if they can command English well enough. They do get support from their community directly as well. Sometimes in ways that is not necessarily the best for them because the EU regulations are complex, are complicated, and there is a lot of misinformation. There is a lot of myths going on. There is even to the point where sometimes we meet clients who might not apply for settled status because they have been told all sorts of weird things about it. But there is in general access to advice and support. And if clients from our point of view, users are being supported at the right point, they tend not to fall through the cracks. Sadly, that falling through the cracks unfortunately happen, and it does happen because the situation of EU nationals at this very moment is not clear to the public sector, as in, for example, local authorities. Or
Barbara, can I put you again on that point? You are looking at, online of course, experts on migration and citizenship. We members of Parliament, that is our bread and butter. We are very experienced. What surprises me, and could you come back to me on this, how little I have had in terms of the demands on my office, and I've talked to many colleagues on this, that people who are uncertain about their status, I find very few are coming to me as a member of Parliament when normally I do get is that the system working well? Or do they not understand that MPs are rather good at this?
It will depend on the EU group of residents or constituency what you are looking at. Our experience is that Eastern Europeans in general are much less willing to seek out help from broader kind of society. They more rely on their own networks. That is partially because people feel that they are not equals. And they literally do not feel they are equals. They don't feel that they are that they will be seen as equal residents. Therefore, they will not have drive to speak with their local MP, for example, because they don't see local MP as representing them. They are being told they are immigrants, and they are being told that they come here to do bad things sometimes, such as stealing jobs. And quite frankly, it is very, very disturbing, but quite high level of EU nationals harbor this feeling, quite frankly, which is quite painful because I am EU national and I believe that we should be seen as treated as equals as we are by and large, obviously. But there is the natural mistrust a little bit, I suppose. And
I know we're short of time. Can I ask the other two to come in on that as well? And I've got one last question for you in a moment. So, Barbara, can I hold you and get the other two very quickly? I know the chair will be leaning on me any second.
If I could just respond very quickly, for the whole session, I was talking as a migration expert, as you said, and thank you for very kind feedback on this. I wanted to say something as an Eastern European, perhaps, rather than an expert. I think what Luke has mentioned about that mobilization, the sense of anger in EU citizens, I think it's felt much more in some communities than in others, and it very much links to what Barbara has been saying. I think there are Europeans who feel that they've really entitled to be here in the UK, and I think there are Europeans who don't feel so much like that. These would be the people that arrived after 2004, who took up low-skilled jobs. I've got a PhD from a university now, but my first job was to clean dishes in a restaurant after I completed my undergraduate degree. And this kind of experience combined with seeing a lot of tabloid front pages over years and years and years embeds a sense of inferiority in a lot of people, I think, and it's really hard to break out of that. And how do
you think people you've been talking to and listening to reacted to the Prime Minister suddenly saying we're inviting 3 million people in Hong Kong to have a special passport to come to the United Kingdom? Was that well received? What was the interest in that kind of gesture?
Personally, I would welcome that, but but I think that this is where we can potentially move away a little bit from the.
It's another 3 million, of course.
It's another 3 million, yes, and I think, but there is,
which I support. I don't want you to think I'm anti-immigrant or in any way. I have a long history of trying to encourage people from Hong Kong to come here. But the point is, what was the reaction in the community to that kind of attitude to 3 million people in Hong Kong and the 3 million people here as EU citizens?
If I may, in my experience, what happened during the course of the negotiations between the UK and the EU was to treat people like bargaining chips. And that was very much a very strong feeling that people had, is that they were brought into a negotiation when they didn't need to be. And that definitely did create some very, very strong feelings. I also think that there is a lot of mistrust in the way that government does things, particularly the Home Office. And that has come about not just because it's become about because of a legacy of mistakes and some very, very bad things that have happened to human beings. And I think a lot of EU citizens are very worried that that will happen to them. And there's a lot of mistrust, which is why you see these things of big surveys saying, we want a physical document, because they don't have faith in the process and they don't have trust that it's going to be done properly. And it's the other reason why there's so many organisations that have come together to try and support people through this process, again, because of that lack of trust. And I think, speaking as an immigration practitioner, as a lawyer who works in this area, I always say when big announcements are made that we need to see the substance, we need to see the detail. And I think that's been very much seen in the way that this EU settlement scheme and indeed the way that rights are being implemented and rolled out is that there's always just a little shift to the left or a little shift to the right. And I think those sort of anxieties I have towards those who are BNOs and trying to, and will be looking to exercise whatever options are available to them. And I would expect the same anxious scrutiny to those laws when they arise. So I do feel that there's a lot of work to be done in terms of building trust. And for example, the government did promise that they would publish the equalities impact assessment of the EU settlement scheme by spring this year. Now, I know the weather doesn't seem like it, but it is summer now, and we've not seen that report. And the ICIBI, the chief inspector, he said, one of the reasons why that report needs to be published is to install trust in the process. And without that information and without that insight, that trust is just going to continue to be eroded, I'm afraid.
I think that puts the finger on it. Thank you for that.
Okay, thank you very much indeed. Just a few final questions from me. First of all, you gave an example of where someone's photograph had been changed on their digital record. Presumably you have, and that could only have been done by hacking the Home Office system, because when someone has access to their digital record, they can't change any of the details, can they? Only the Home Office can do that. Is that correct?
Yes, that's fine.
Yes, fine, okay. Because, I mean, this could be a potential source of criminality. If people want to say, I can get you your identity, I'll hack into someone else's record and change their photo. So have you raised that with the Home Office? What did the Home Office say? Kuba, I see you're putting your hand up.
I just put my hand up to say that it's not just the Home Office specifically that would have access to this, because the kind of data handling side of the EU settlement scheme is not in the public domain. We are told that the Home Office can pass the details collected through the application to other public, private bodies and charities, but we had a freedom of information request around it, and we didn't hear who they were. So.
But there's a difference between passing the details and those who have the capacity to alter the record.
Yes,
now, I presume the only people who have the capacity to alter the record officially are the Home Office. Is that correct? Is that your understanding?
I don't know that. Yeah, but Luke perhaps will.
It'd be very odd if anyone else had the capacity to alter the record, wouldn't it?
It would be very odd indeed, given that it is a Home Office system. In that particular example, it was more so, where did this other picture come from?
Sure.
And what triggered that event?
Right, but it wasn't, the right picture had been there originally, and then when somebody logged on, they found there was another picture.
Yes, that's
so
nice.
I mean, but it could have been, because you used the word hacked, could it potentially be an error on the part of the Home Office by putting the wrong picture in the, as opposed to someone hacking the system?
To be clear, I think I didn't say that was the product of hacking. I was saying that there was a risk that the system.
Fine, okay, all right. I just wanted to clarify that.
What I'm saying is that part of the anxieties of a digital-only system is that things can be changed without people knowing, and that was an example of that.
Okay, all right, that's very helpful. Now, refusals of applications, the numbers have been relatively small. Do you have any concerns about the refusals? I mean, there'll be refusals, presumably on grounds of previous criminal convictions, and there'll be refusals on the grounds of you're not actually eligible for the scheme. But do you want to very briefly say what your concerns are? I don't know who wants to. Is there anything you want to say? I mean, you have referred to it in your evidence, but
yes, I mean, the slight concern here is that there were no refusals until the end of January, and the latest statistical report on the new settlement scheme says quite casually that in February 2020, the Home Office decided to start refusing applications. We have seen one refusal in particular, which has waited for 7 months. To be decided. It was refused, this case was refused correctly on eligibility grounds, but it seemed that the applicant was kept waiting for no obvious reason until February, March to be refused. And since February, we have seen a stable amount of those refusals coming through. 99% of them are on eligibility grounds. So criminality refusals are only a small proportion of that number. Yeah. And we understand that more than half are for family member applicants, so for non-EU applicants. And that would be quite concerning. That is quite a high number, given that EU family members comprise only a small proportion of all applications, but more than half of all refusals. So that's
okay. That is very helpful. Now, universal credit, and obviously there is the court case at the moment. Because you've written and said you think that the way the government is interpreting the rules is not within the spirit of the agreement. Can you just explain that again briefly? And can you just clarify, if someone is in the country, makes an application for universal credit and then leaves, are you arguing that people should get their universal credit paid to them if they're not living in the country?
So,
Luke.
Yes, if I may. The issue, in short, is that the manner in which people are tested to access universal credit is they have to have been habitually resident in the UK.
Yeah.
Now, the hurdle that exists at present is that for an EU national to qualify and pass that test, they have to either have a permanent right or have been a qualified person, so worker, self-employed, etc. Now, with status under the EU settlement scheme, settled status gives you indefinite leave to remain. And so long as you are living in the UK, you're resident here, and you've got your ILR, you are eligible for help. Now, if you've got pre-settled status, you not only have to show that you're resident in the UK, but you still have to show that criteria of being worker, self-employed, etc., etc. Mm-hmm. Now, why is that problematic? Why is that problematic in the context of the EU withdrawal agreement? Now, the problem is that under a constitutive system, the rights associated with your status are activated when you are granted your status. So if you're granted pre-settled status, you therefore have rights under the agreement. And that seems to be very much the interpretation of the European Commission. They've said it in correspondence to us, as well as their guidance document. They explicitly say that the rights associated with the agreement flow from the grantor status. Now, it appears to be that the UK's position is to say that, oh, well, you may have been granted your status, but we still need you at the point of seeking to get universal credit or housing support. You still need to show that you are or were a qualified person for the appropriate period. So what we have is an unusual situation, which it would appear to be that we have a constitutive and declaratory system combined in one by the UK government. So you get your residence right to live in the UK, but you still have to prove the declaratory elements when you wish to access universal credit and so forth. So there's some concern there.
Okay, and now this is subject to further consideration by the courts, because I think it's working its way up through the system. So we'll have to wait and see what happens. Just two other very quick questions. One is, what is your understanding of what the status of people will be if they have applied before the June 2021 deadline but have not yet been given a decision?
Well, they have the right until a decision is made. If you apply before the deadline, then you have the right until a decision is made.
How will they demonstrate that to a potential employer or a landlord?
I'm glad you asked me that question, Hilary, because it's an important one. And the withdrawal agreement says that if you apply, you get a certificate of application immediately. And that certificate shows I have a pending application with the Home Office, I'm waiting for a decision, and the rights associated with that are informed on the face of the certificate. So it's really important that these certificates are issued to people who've applied, particularly as we get closer to the deadline, because there may be a delay, as you say, and they will need to prove it. And what we've seen, both in my personal practice and reports that have been given to me, are considerable delays in those certificates being issued. They are not being issued immediately.
Are they going to be physical certificates?
They are not. They are digital.
So it's the same issue we were discussing earlier. And finally, the Home Office is going to need to have some criteria for deciding, if people apply after June 2021, whether they had reasonable grounds for doing so, i.e., why did they not apply previously? When do you expect that to be made available? And obviously you have views about what you think would be reasonable grounds, given what you said earlier about children in care, people with dementia, people sectioned under the Mental Health Act and other things like that.
If I can start with that point, and I think it comes back to the point I was making earlier, which is I would like to know who in what situations it is not reasonable for somebody to be able to apply after the deadline. We focused a lot on what would be reasonable, but I'd be very interested to know when it would not be reasonable for people to apply. Is it just because you forgot? Is it because you thought you were okay and then you realised that you weren't? Is that unreasonable? So I think there is a lot to be worked through here, really, for it to be realistic. And I think it's not just, I think the burden can't really just be placed on the applicant in the situation. There has to be a bit of a understanding of, you know, how the system as a whole is working and if it's working effectively at reaching to these people. But the government has said, you know, the examples they typically give are the ones that we've been talking about today, which is quite understandable. But there is a sliding scale, and I think that does need to be pinned down a lot more. And the expectation is that the details are to come later in the year, but the sooner the better, because then we can have a dialogue about it, you see, and we can improve it.
Okay. Right. Well, that concludes the session. On behalf of the members of the committee, can I say a very heartfelt thank you to you, Luke, to you, Barbara, and to you, Kuba. It's been a really excellent session, and we've learned a lot, and you've been very generous with your time. Keep safe. Order, order.